on contracts class. We were driving home from Arizona yesterday and didn't get it out. So anyway, we'll go over exclusive right to buy. If you guys have questions, just as normal, chime in. I'm not here to listen to myself. So uh, obviously, you'll have your own office branding at the top. You want to make sure that you have the correct version of this contract. And so this exclusive right to buy was updated in 2020. And so you'll see it should say mandatory 1-20, mandatory January of 2020. Okay, so make sure you've got the correct one there. Just like all of our other forms, right? This is a legally binding contract. If you need to talk to an attorney or tax counsel or whoever else, then they have a right to do that. There's also a note on this that we don't typically see on our other forms other than the exclusive right to sell. And it just says compensation charged by brokerage firms is not set by law, right? They can be established by the real estate brokerage firm, right? And so we have policies within our brokerage firm, but outside of that, brokerages should not be cooperating in fixing some kind of commission. And so just real quick, I'll hit on, like, if you guys are part of, like, for instance, the Lab Coat Agents page on Facebook. It's a national real estate agents page. It's got hundreds of thousands of real estate agents across the country in there. And a lot of times they start talking about, like, oh, really, is this, what's going to happen? The co-op commissions are going to drop from 3% to 1%, or, whatever it is. And just by nature of talking about that stuff, I mean, it's not against the law to say commissions to another broker, right? But when you start talking about industry practices and, like, hey, here's what our firm does, here's what our firm does, here's what we think the industry standard should be, right? That's against the law. And so I don't want you guys being a part of those conversations that are happening with respect to setting commissions. Commissions are set between you and your client, and the real estate brokerage firm has a right to set minimum or maximum kind of floors and ceilings on what their brokers can charge. But outside of the firm, whatever happens with commissions, that should just be not a topic that you want to get into. Okay. The next little disclaimer there just says that there's different brokerage relationships available, and we'll talk about those. And then really the important piece is, you need to check a box, buyer agency or transaction brokerage. Now, if you don't check a box, what happens? Anybody know?
Defaults to
transaction brokerage.
Yeah, it defaults to transaction brokerage. And so if we have a contract come through, right, when my wife is doing the compliance, if she sees one that comes through and it doesn't have a checkbox, she assumes transaction brokerage. However, what I don't want is, I don't want you to just say, hey, I'm a transaction broker, so I'm going to skip checking the box. And the reason for that is most people, if this were to go to court, right, and the judge is talking to you and they're talking to your client, right, most of your clients, when they refer to you, what are they going to say? Are they going to say, Harry is my transaction broker, did this? Or are they going to say, Harry, my agent, did this? How are they going to refer to you?
Agent.
Agent, right? That's what everybody calls it. That's what everybody knows it as. And so if you don't check the box specifying that you're a transaction broker, and this thing somehow ends up in court, which, by the way, guys, like, I always talk about worst case scenario, and I've had brokers say, like, hey, if real estate's this, heavy on the liability side, maybe I don't want to do it. It's really not that scary, right? I see the worst of the worst, and I try to prep you for the worst of the worst. But really, in most cases, most transactions are just that they make it through. You're not going to go to court, right? We'll avoid all that. I can't promise that. But anyway, so if it does somehow end up in court, those people are probably going to be referring to you as their agent, even if you don't have one of these boxes checked and you defaulted to transaction brokerage. And so by checking the box, you're at least saying, hey, buyer, you acknowledge that I was your transaction broker, and therefore I didn't have those additional duties in Section 6, right? And so even though you're referring to me as your agent, right, that's kind of a colloquial term that people use because they don't understand the complexities of transaction brokerage versus buyer's agency, right? Even though you're referring to me as your agent, I was in fact your transaction broker, as you know, we designated on the form, and therefore the box was checked. Okay, so in many cases, my wife will send it back to you for compliance, even if you say, well, I was a transaction broker, therefore I didn't need to check the box, right? Well, I want you to check the box so that there's no confusion. Okay. And Liz, this is only applicable really to Loveland, but she said, since the Loveland office is currently looking for new space, will the current contracts, forms, and IRIS be updated to the PO box? Not yet. We technically still have that space, even though we're emptying it out. We're just looking for a new space. And so this will just kind of be our placeholder in the meantime, but it doesn't matter what you have at the top here. You could use an unbranded one from the Real Estate Commission. You can have this address. You can have the PO box address. Doesn't really matter. Okay. And that goes for anybody. You don't, you know, if you're not at the Loveland office, you obviously don't want to use this branding and this address, but any of you can use an unbranded form from the Real Estate Commission. And that doesn't have any logo and it doesn't have any address or anything. This is the very top part of that form, is this box here. And that's perfectly acceptable. It's no less of a binding contract or anything like that, just because it doesn't have the branding. That's perfectly okay. Okay. All right. So a couple of things. One, you've got the date of the contract, which may be different than the actual start date of the listing period down here in section 3.6. Okay. So, you know, in most cases, it just makes sense to have the date of the contract be the start date for the listing. However, you know, you might come across a buyer who says, hey, Jerry, you know, we've been working with this broker and they really have not done a whole lot for us. Our listing with them expires, our exclusive right to buy with them expires on April 30th, and we would like to have you be our buyer's agent starting on May 1st. Okay. So you can actually write a contract dated today, right? And you can have the listing period start on May 1st, even though they're currently, you know, bound by an exclusive right to buy with another broker. And that's okay, as long as they approached you about it. Now, if you know that someone else is working pursuant to an exclusive agreement with another broker, then no, you cannot go approach them and say, hey, what's your ending date? Like, let's sign an agreement, you and me. That doesn't work. Okay. But if they contact you, that's okay. The one thing I will say is, I don't want you to ever have a copy of their agreement. Okay. The reason for that is, the only reason that you would ever have a copy of their agreement is to interpret something in that form, which you have no authority to do. So even though Conway Bogue gave us the right to fill standard forms and interpret standard forms, and this is a standard form, that authority rests only with forms that were written by you as the broker, not forms that were written outside of the brokerage or even inside the brokerage by another broker. Okay. And so you having access to those forms, really the only reason for you to do that would be to advise the you know, buyer in this case, like, hey, their contract expires on April 30th, and therefore I can sign it on May 1st. And so a lot of buyers in this case say, well, you know, I don't want to get in trouble. Like, you know, when can you start being my buyer's agent? And you need to kind of turn that back to them and say, well, you need to figure that out with your current broker, or you need to talk to an attorney. I really can't advise you on that, right? It's outside the scope of my authority. And if you do advise them on that, then it's called the unauthorized practice of law. And that's a good way to get your license taken away, even if you were correct in your, you know, assumptions as to when you could sign an exclusive right to buy with that party. So if there's a form that was drafted by another broker, I just don't want you to have anything to do with it. If they happen to send it to you anyway and say, hey, Jerry, when can you start? Then you just say, hey, I haven't even read this form, and I'm not going to, because I can't interpret it for you anyway. You either need to talk to your current broker about that and let me know when I can start, or you need to have it reviewed by an attorney, or you need to just make the decision yourself with your understanding knowing that there's a possibility that you could potentially be on the hook for 2 commissions if your interpretation of this contract is incorrect. Okay, so I know brokers want to, you know, go above and beyond for their client. They don't want the buyer to have to pay for an attorney, all this other stuff. And if that's the case, then just have them go talk to their other broker, say, hey, when does this expire? Because you're not cutting it for us, and we're going to sign with somebody else. Okay. The agreement. So this piece is super important. And you know, effectively what it says is that you know, the buyer and you, the broker, on behalf of the brokerage firm, you're entering into an exclusive agreement, meaning they are agreeing to work exclusively with you. Now, you aren't necessarily agreeing to work exclusively with them. You can have other buyers, and that's actually spelled out later in the contract, but you can have other buyers and not be violating your duties to this particular buyer by working on behalf of other buyers as well, even if they might be interested in the same property. And we'll talk about that a little bit later because that gets to be a little bit interesting, okay? So it's exclusive, it's irrevocable, so it cannot be revoked. Now, the parties can mutually agree to revoke it or terminate it, right? But it is not a unilateral contract where one party has the right to revoke the contract or terminate the contract unless there's some specific things that happen, which we'll talk about later. But it's irrevocable in the sense that unless both parties agree to something else, or unless one party to this contract defaults, then the contract remains in place. They can't just say, hey, you know, my bestie just got their real estate license, and so, you know, we're going to go work with them instead. You've been great, you know, yada, yada, whatever. No, it doesn't work like that. It's irrevocable. Okay. And this agreement is the buyer listing contract. And so anywhere you see buyer listing contract, right, it's referring up to this agreement. And the agreement is that the broker is you are going to agree to provide brokerage services to the buyer. And on behalf of you know, whatever is spelled out below, you will be compensated potentially, and it's determined based on the check boxes that get checked below. And so that's what's really important right now, because what do you guys, anybody seeing commissions just on a general level kind of slowly starting to go down? I know there was some discussion on the Castle Rock page, which is fine. You guys can discuss within your own offices commissions all you want. But I saw on the Castle Rock page, someone posted and they said, hey, what the heck is up with this, you know, buyer's agents, you know, having to take 2% or 2.5 instead of 2.8. Okay, within the office page, right? But having that conversation outside of, you know, your office is, you're getting into price fixing and Sherman Antitrust Act stuff, and you just don't want to go there. So, but overall, have you guys seen in the MLS, have you guys seen co-op commissions starting to come down? So there's a big home builder, which I don't think they're building in Colorado. Maybe they're building down south, but I don't think they're building up here. But a big nationwide builder by the name of Ryan Homes, they actually just stopped compensating buyers brokers altogether. Okay. I'm under contract with Richmond American, and they pay 2% of the base price. No, you know, not the final price, nothing else. It's 2%. Doesn't matter if you've got, you know, an exclusive right to buy that says buyer, you're obligated to pay, and you try to write 3% in there, 2.8% in there, whatever your number is, they're paying 2% of the base price, and that's it. Okay.
So Jesse, are you just eating that then? You're not going to your buyers, or how are you?
Well,
since you've already got this, you know, exclusive right to buy in place at a certain percent commission.
Yep. So we'll talk about that later. So hold that
Okay.
thought. And it may actually be next week by the time we actually get there.
Okay, sorry.
But we will cover that, I promise. Okay.
Hey, Jesse, is it Ryan Homes or Ryland Homes?
Ryan, R-Y-A-N.
Okay.
Yep.
Not heard of them.
And you know, there's other builders that are doing it too, whether it's completely, you know, stopping their cooperation with co-op brokers, or, you know, dropping from what they used to pay to a lower amount now. And it's something that we always see in a hot market, right? I mean, why should they compensate you when they can just go sit someone in their sales office and sell out their inventory in 8 hours? Like, well, why pay extra commission that they don't need to, right?
Well, there's even some home builders though, Brookfield, one in particular, they're paying 4%.
Yeah, yeah, and there's again, there is no standard, right? And so that's perfectly okay. St. Aubin is a builder that builds both down in Castle Rock and up here, and they pay 3% on the full purchase price, and they're still doing that, right? And so there's a continuum, right, of nothing to whatever. There might be builders out there at more than 4%. I doubt it, but wait till the market turns around, which when is that going to happen? I don't know, but not in the foreseeable future, in my opinion. But wait until the market crashes, and they're going to be begging real estate brokers to bring their clients back, right? So just that's part of why we're going over this today, is so that you can make sure that you're protecting yourself by filling out your exclusive right to buy in a way that doesn't mean that you're going to be working for free. Because if we go back to this agreement, right, nothing in this agreement says that you will absolutely positively be compensated at all costs. No, it says but on the flip side, it says you absolutely will provide brokerage services to the buyer. And then depending on how you filled out the rest of the form will determine whether or not you're going to receive any compensation, right? And so the agreement is there's an absolute for you of you will provide brokerage services, even if it means you're getting zero, right? And then you may have built in some protection depending on how you fill out the rest of the contract that would potentially require the buyer to pay, any shortfall. So we'll get there when we get there. But that is the agreement. Says you agree to provide brokerage services, and in exchange, you will be compensated depending on how you filled out the rest of this form. Okay. All of us work as part of a multiple person firm. So unless you were to break off and become an individual, right, then you could check that box. But we're all going to check 2.1 that just says, hey, we're an individual designated by the brokerage firm to be the designated broker for the contract. If more than one individual is so designated, then any reference in this contract to broker includes all of those people. And so if you're on a team, for instance, your exclusive right to buy and your exclusive right to sell should mention, either here in 3.3 where it talks about broker, or down in the additional provision section, it should say, the ABC home team is comprised of, broker, and broker, right? So you need to list everybody somewhere in there, and then all of those are referred to as the broker. Now, one other caveat there is that the real estate commission treats teams as an individual person, right? And so you might have, let me see who's on the call here. Is anybody part of a team who's on this call? I don't think so. But
based out of Kansas City. So
okay.
do I have to, they don't even have a Colorado license. So would that matter at all? Or is it just like my 4 team members here in Colorado, even though they're in, Fort Collins?
Yeah, good question. So if they don't hold a Colorado license, then no, right? However, if you're part of an expansion team and your expansion team has people, in 4 different locations in Colorado, then really everyone on that team is treated as one by the real estate commission, and they should be listed on your contracts. Now that gets a little bit weird, right? Because they're, it's not like the person in Colorado Springs, let's say there's you have an expansion team in Colorado Springs, it's not like they're going to have any actual knowledge with regards to your transaction. However, the real estate commission doesn't care. If you're on a team, you're on a team and you're treated as one person. Right now, we can't bind anybody outside of the state of Colorado, right? But if you're on a team, you're on a team. And so forget about the expansion model, but let's just say, that Gabe or Gabriel, that you were on a team with myself and Harry, and we all existed within the same office, right? Then we would have to say, hey, you know, the ABC home team consists of myself, Harry Davis, and Gabriel, right? So all of them need to be listed. For you, the expansion model, right? If they're all part of the same team, then they're still all part of the same team, even though they're not, you know, even though they have nothing to do with the transaction. And where it gets weird is like, even if you're in the same office, right? I might be like the team lead, and I might have Harry as my listing specialist and you as my buyer specialist, and you guys never talk to each other as far as like, hey, you know, here's some confidential info that, you know, on behalf of the seller, and here's some confidential info on behalf of the buyer, but you're still treated as one. And so where that gets a little bit unique is if our team, right, would then have a listing, Harry shows up as the listing broker in the MLS, right? And Gabriel, you bring the buyer. Well, you can't have Harry be a seller's agent and Gabriel be a buyer's agent. It doesn't work that way because you're treated as one and you have the same relationship as all the other brokers on your team. And so if Harry is a listing agent for the seller, right, as opposed to a transaction broker, if he's a seller's agent for the seller, then you have to become either transaction broker where Harry shifts into transaction broker, or you have to treat that buyer as a customer because of Harry's relationship with the seller, right? And so what happens if you're doing a deal with someone on your expansion team who's out of a different office where they have the listing and you have the buyer? That's where it gets super weird because you technically still have the same relationship as your other team member in a completely different office, right? So that gets super weird, but yes, that is still a thing. Yes, you are still treated as one. Okay. Okay. So section 3 is where we're going to talk about, you know, we're going to define the terms, right? The buyer, you're going to put all of the buyer's names on here, and best to have it as it's going to appear on the contract to buy and sell. So if they're going to have, you know, their full middle names on the contract to buy and sell, best to put their full middle names on here, just so there's no confusion. If there's going to be 2 people on the contract to buy and sell, it's, you know, best to put both of those people here. Okay. Now, how important is it? Well, it's not incredibly important that you have to have it exactly as it is, because that the text down here says, and any other person or entity on whose behalf the named party acts, indirectly, directly, doesn't really matter, right? And so, you know, even if you only have one person on here, they can't try to say, well, Harry, you know, you didn't have both of our names on the exclusive right to buy, and so therefore you can't hold us to the terms of this contract since only, you know, since we were both on the contract to buy and sell, right? You can't hold the second party liable since they weren't on the contract. Well, if the one party that you had on here was acting on behalf of someone else as well, directly or indirectly, then it's still going to apply. But just to avoid the confusion, avoid the lawsuits, the complaints, best to just get everybody on there, okay? Brokerage firm obviously is going to be whatever brokerage firm you're part of, not just Keller Williams, right? Keller Williams Realty First Associates, Keller Williams Realty Partners, Keller Williams Action Realty, Keller Williams Realty Northern Colorado, any other firms that we have on this call, okay? That would go here. Broker, that's going to be you. Property. So I love when I see in section 3.4, when brokers just writing here, you know, any property that meets the buyer's requirements. Well, it's asking you what property meets the buyer's requirements. And so coming down here and saying any property that meets the buyer's requirements, that does you no good to put in your contract, right? So you need to have something that is, you know, easy to define, right? And so a couple different ways that you could go about this. You can start listing specifics, right? And say, well, you know, any home that has at least 3 beds and at least 2 baths and is located in Larimer County, right? Well, what happens then if they buy a home that is 3-bed, 2-bath, but it's in Weld County. Well, they could certainly make an argument that, hey, you tried to force me into something that doesn't substantially meet my requirements, but who gets to define substantially? Well, it's not a defined term in our contract, and what that means is that that's subjective, right? That there is no concrete definition as to what substantially meets those requirements. Is a 3-bed, 2-bath house in Weld County substantially similar to a 3-bed, 2-bath house in Larimer County? Well, I don't know. I mean, I guess it depends on the circumstances, right? And so rather than getting specific there, and rather than trying to just encompass everything and say, any property that has at least 1 bedroom and 1 bathroom in Weld, Larimer, Boulder, or Jefferson County or whatever, right? Like, all I do is I just put any real property in the state of Colorado. Okay. Is it easy to define a real property in the state of Colorado? If it's a real property and it's in the state of Colorado, then it's subject to the terms, right? Now, does that mean that I'm going to go show them property in Grand Junction? Probably not, right? I'll just refer it out and terminate my agreement with them. That's fine, but they're bound by the terms of any real property in the state of Colorado. Okay.
A lot of people write TBD.
Yeah, and that doesn't do you any good either, right? Because
Okay.
At what point are you going to determine what property substantially meets the following requirements? What happens if you are at the closing table, right? And the buyer says, no, we don't think that you met your obligations under the terms of our contract, because you didn't sell us a property that substantially meets our requirements. Well, you would think that putting them under contract and getting all the way through the process substantially met their requirements for a property, right? But if you didn't do your part to define that, then I don't know, was there coercion? Was there, some kind of threat, right? I don't know. If there was, then yeah, they probably have the right to say, hey, you didn't meet your obligations under the terms of our contract. And how do you prove that? I don't know. The proof is get it in writing when you do your contract. Any real property in the state of Colorado is easily defined. If they buy a real property in the state of Colorado, they can't say it doesn't meet their requirements, because that's what we've agreed to, right? And so I just think that offers you the most protection. Not saying it's right or that you have to do it, but just think about that when you're writing this, of how much protection do I want to offer myself, right? And again, you could put TBD, but you're opening yourself up to the possibility that you get your commission taken away after the fact, right? Or that you never actually earn a commission. So be careful about how you fill it out, okay? All right, section 3.5. So this is incredibly important with respect to commissions, as this is going to apply later, okay? And so what 3.5.1 does is it defines a purchase, and you'll see it's capitalized, right? So a purchase of the property means the acquisition of any interest in the property or the creation of the right to acquire any interest in the property, including a contract or lease. So effectively, once a contract is signed by all parties, at that point, your buyer has an interest in the property. They've acquired an interest in the property by creating a future right to, purchase it, to occupy it, whatever. And so once you have a fully executed contract, you have met the legal definition of a purchase, okay? Now that doesn't mean that your commission is payable at the time of the fully executed contract, and we'll talk about some instances where that may not apply. But for the terms of this, right, a purchase means the creation of the contract signed by all parties, or actually acquiring an interest in the party where, they close on it and they take title to the property, okay? It also includes an agreement to acquire any ownership interest in an entity that owns the property. And the reason they put this sentence in here is that what happened was there was a case where the buyer effectively wanted to skip paying, or what was it? It was I think it was a seller. The seller wanted to skip paying a commission, right? By saying, hey, the buyer that was named in this section 3.1 was not the buyer who took title to the property. Well, what had happened was the buyer created an LLC, or they bought into an LLC, which ended up purchasing the property, right? And so effectively it was just a shell game where the buyer said, I'm not going to take title in my name, but I'm going to purchase an LLC or create an LLC, and I'm going to take title in the name of the LLC, right? Okay, well, if that's the case, the commission's still going to be payable, right? So that's why they added this, is that it was born out of a lawsuit where a seller was trying to avoid paying a commission because a buyer took title as an LLC instead of the buyer's name, okay? So
Jesse, in that case, would you put the buyer's real names and the LLC, or just the LLC up there, or you put their name, correct?
well, I would
You
typically
meant with them?
I would typically put whatever I truly expect at the time that this contract is written. So if it's going to be the LLC, at least as far as we believe, then I'll put the
Okay.
LLC here. If it's if I believe it's going to be the buyer, then I'll put the buyer's name here, right? And
But not
again,
both.
we're offered some protection in the sense that it can be or any other person or entity on behalf of who the named party acts. So
Okay.
again, it's not crazy important, right? But
Okay.
you should do it the way that you expect it's going to be done. And then we've got protection on both sides, right? Where we're saying,
Right.
hey, the buyer is either the name or someone who they're acting on behalf of. And then the purchase, right, is also subject to the same thing, right? Where if they take title under some other name or some other entity or LLC or whatever, right, then it still applies. That still counts as a purchase of the property, okay? In most cases, we're not going to negotiate a lease. If we were, then we would check the box in 3.5.2, but otherwise we can just leave that blank, okay? All right, the listing period. So we already talked about the beginning date, right? And again, this can be the date that you write the contract. It can be a future date, but that's the date on which your listing period technically begins, and then it will continue through the earlier of the completion of the purchase. Now, remember, this is a capitalized P right here, right? And we define purchase up here as the contract. So does that mean that you're done once you sign the contract? What do you think? You guys done once you sign the contract?
No.
No, right? Completion of the purchase of the property means you've taken it all the way through closing, right? You've actually closed on the property. And what's interesting is that I think the next time that this contract gets revised, I think what we're going to see is there's going to be something in here regarding post-closing occupancy, because right now it's really not incredibly clear whether the post-closing occupancy period is a period of time where you still have brokerage obligations, brokerage duties to your client. Now, conventional wisdom and effectively what the courts have been holding is that yes, you still have obligations during that time. And so I think what we'll see the next time is that will just become more clear, that yes, you are still obligated to represent your client during the period of the post-closing occupancy, okay? So completion of the purchase of the property or the lease of the property, and then this would be your end date, right? Now, what you can't have is you can't just have an open-ended, like you can't just leave this blank. You can't have TBD, right? You have to have an end date to your listing agreements. And just so everyone is clear, a buyer's, this is an exclusive right to buy listing contract. So yes, it is still a listing agreement, even though it's a buyer listing agreement, right? So you cannot have an open-ended listing agreement. You have to have an end date. It is actually a real estate commission rule. Okay, now they've revised the rules, and so it's no longer an E rule. They now have numbers and whatever. So I can't remember what number it is, but it used to be what, Jerry, E7 or E11 or something like that. So it is an actual real estate commission rule, meaning if you don't put an end date here, the real estate commission can take action against your license. Okay, so okay to have TBD at the beginning, although I wouldn't recommend it. I would just make it start on whatever day you're signing the agreement, or if there's another agreement currently in place, then make it upon the expiration of that first agreement, right? But you have to have an end date. Okay. The other thing that I'll tell you, and I butt heads with Damien a little bit on this, is that if you look in the Colorado statutes, it says that listing agreements cannot be, well, it doesn't say they can't be longer than a year, but it says that the listing agreement will terminate upon the purchase of the property or 1 year, right? Or whatever is written as your expiration date, not to exceed a year. Okay. So Damien believes that you can have it for longer than a year, and I'm just telling you, you can't. Okay. And I'm right. Damien's wrong. Don't tell him that.
Sure.
You shouldn't have it go longer than a year. Okay. Because I think you're just opening yourself up to a battle in court. Okay.
Hey, Jesse, I've got a quick question on the start date. So say you draft up the contract and you send it over to your clients and they don't sign it for another week. What happens to that start date?
Well, you don't have a contract, right, until it's signed.
Correct.
You've got a draft of the document. And so it gets a little bit weird of like, well, you know, we didn't have a contract in place until, you know, what today is, let's just say, I don't know, May 3rd, right? Well, it was supposed to start today, but it didn't get signed today. And therefore, what does that mean for you as to how you are to treat your clients until it gets signed?
That you treat them as a customer till it's signed.
Well, by default, what are you?
A transaction broker.
Yeah, by default, you're a transaction broker, right? And so this is where it gets super weird, is if you check the box that says, hey, I'm going to be your buyer's agent, right? And you say, hey, the start date is going to be April 27th, and then they sign it on May 3rd. Well, what happened if you went under contract between April 27th and May 3rd? You stepped outside of your brokerage duties if you treated them as a buyer's agent, right?
Right.
So just the things that agents come up with, you know, never ceases to amaze me. And I talk to Harry about this all the time. Harry's laughing because he calls me and he goes, you'll never guess what I saw on a contract today, right? And it's always, you know, how in the heck does somebody come up with this crazy stuff, right? And so, yeah, agents come up with some weird stuff. You have some weird situations that obviously our contracts were just not created to encompass everything. But yeah, by default, you're a transaction broker unless and until they sign that agreement. So be careful not to step outside of your lane as a transaction broker. You can't take on those 3 additional duties of a buyer's agent unless and until they've got it signed. Okay. That makes sense.
Thank you. Yep. Thanks.
Cool. Let's see. So the completion of the purchase of the property, release of the property, or whatever your expiration date is, and then any written extensions of the listing period. Okay. And so again, this is where the 1 year thing gets a little bit weird, right? Is let's say that everybody signs it today, April 27th, 2021. And you have April 27th, 2022 here as your expiration date, right? And then on April 26th of 2022, you do a listing contract amend extend to extend it for another year because, you know, they ended up not buying a property because the market was crazy and they didn't have enough of a down payment or whatever, right? Well, if the law says that your listing contract expires after a year, then you do a written extension to a contract that is dead at that point, I just don't think it holds up in court, right? And so I think if you hit a year, you just need to do a new one, because there's a 33% chance that we have a new contract at that point anyway, right? And the law says otherwise. So I think if you go beyond a year and you have to do, you're going to extend it, do a new contract. Don't do a written extension, okay? Anything less than a year, extend it all you want. Nobody cares, okay? He'll continue to assist in the completion of any purchase or lease for which compensation is payable. Now, when this sentence was written in here, lease was not really, determined as the post-closing occupancy agreement, right? Even though it is a short-term lease effectively, that's not what was contemplated here. So again, I think we'll see this section get updated. I don't know for sure, but there's talk about, making sure that that's clear, that yes, brokers, you still have an obligation to assist through any post-closing occupancy in the contract, okay? Applicability of terms, same as any other contracts, right? If it's NA or deleted or blank, then it's not applicable. If we use MEC somewhere, it means the date upon which all parties have signed the contract. That makes sense. Any questions on that piece? Okay, 3.8 days, same as all the other contracts, right? It ends at 11:59 p.m. unless it's stated somewhere else in our contract. And then, do you want any dates and deadlines in this contract, right? Not the contract to buy and sell. This is the exclusive right to buy. Do you want any deadlines in this contract to be extended to the next day that's not a Saturday, Sunday, or holiday, right? And this is federal or state holiday, okay? And really, unless you write in some funky dates somewhere else in the contract, right? These are our deadlines in the contract. Is really the expiration date is the one that you're going to be most concerned about. And why not have it extend to the following day that's not a Saturday, Sunday, or state or federal holiday? So in this contract, I typically say, yes, my deadlines will extend, because then if my expiration happens to fall on, Veterans Day or Memorial Day or Labor Day or whatever, right, then it will just get extended to the following day. And probably if you haven't found them a home by the time it expires, then the one extra day is not going to hurt anything anyway. But there's no right or wrong. If you want to check the will not box, that's okay too. Okay.
Jesse, do you typically have, like, when you have a deadline in there, do you put 11:59 typically, or do you put like a decent hour so you're not waiting up until midnight?
Good question.
Put like 7 o'clock or 5 o'clock in the business day. I know that's come back several times with listing agents. Why did you put that in there? Well, I was like, yeah, because my buyers didn't want to sit up till midnight, and I texted her, I emailed her, I called her to make sure the sellers could sell, and it still came back to, you should have put 11:59. I was like, anyway.
Yeah, so I typically just leave mine at 11:59 p.m. And really the reason for that is that's how I've been operating for 13 and a half years, right?
Okay.
There's no sense for me to change it. If you want to start out and, have it be 5 o'clock p.m. or 8 o'clock p.m. and just operate that way on all of yours, right? Then write it into all your contracts, that's fine. But the problem is, after you've been doing it for so long and you that's your understanding of the way things work, then
Right.
all of a sudden you get one contract where things end
Yep.
and you're like, oh,
Throws
I
you
don't
off.
have plenty of time to deal with this. And then lo and behold, your deadline goes and you've missed your opportunity to object or resolve or whatever it is. So I just
Mhm.
like leaving it at 11:59 p.m. There are some, institutional sellers who will require that, hey, day ends at 5 o'clock p.m., right? And you just got to be careful. You need to know
Right.
how that affects your deal.
Mhm.
If all parties agree that it's going to end at 5 p.m. instead of 11:59 p.m., then you got to be up on your dates and deadlines, and you need to know that, hey, if I miss 5 o'clock, I'm done.
Right.
Okay. So there's no right or
Thanks.
wrong, but I just leave it. Okay, so brokerage relationships. So this is where, well, we talked a little bit about the brokerage disclosure to buyer form last week, right? And if you are doing an exclusive right to buy right up front, your first reasonable opportunity and prior to soliciting any confidential information or anything like that, you don't need to do a brokerage disclosure to buyer because all of that is contained within this form. And especially if you're going to be a buyer's agent, then it really doesn't make sense for you to do a brokerage disclosure to buyer, because in a brokerage disclosure to buyer, your only option is either treat them as a customer, which you would only do if you have an agency relationship with the seller, or treat them as a transaction broker by default, right? And so you can't establish an agency relationship with a brokerage disclosure to buyer. And so if you're doing this exclusive right to buy right up front, particularly as a buyer's agent, doing a brokerage disclosure to buyer just doesn't make sense. You're going to sit there and tell them, okay, by default, I'm going to be a transaction broker for you. Here, sign this. And then, okay, now I'm going to be an agent for you. 2 seconds later, sign this. That's dumb, right? So you don't need it if you're doing this at the first reasonable opportunity and prior to soliciting any confidential info. However, there's no way for compliance in particular to know, hey, did you do this at your first reasonable opportunity or did you not? If your exclusive right to buy is dated and signed at the same time as your contract to buy and sell, then probably you need to have a broker disclosure to buyer, right? Because if they're signed at the same time, you've probably been out showing them properties. You've probably been advising them as to, how things work and, trying to advocate for them, right? You're now writing a contract for them or you're advocating for them. So you've probably had an opportunity to discuss confidential information, and therefore you should have done a broker disclosure to buyer previously, or you should have done this form previously, right? And so if your files ever get audited by the real estate commission, you don't want to get popped by having your exclusive right to buy be dated and signed the same time as your contract to buy and sell as an agent, right? Because you've probably not done your statutory duty of disclosing your brokerage relationship with them at the first reasonable opportunity and prior to discussing any confidential info, okay? So everything that's in that broker disclosure to buyer, though, is contained here in the exclusive right to buy. And so what this says is, obviously, if that agency box is checked at the top of the contract, then you're going to be the buyer's limited agent, which we all know as the buyer's agent. And if the transaction brokerage box is checked, then you're going to be a transaction broker. And again, by default, you'll be a transaction broker if nothing is checked, okay? And that's spelled out down here later as well, okay? Now, if there's an in-company transaction with different brokers, so for instance, let's see, Liz and I are both part of the Loveland office, right? And so if I am a seller's agent for the seller and Liz has a buyer whereby she is the buyer's agent, right, then I can maintain my agency capacity. Liz can maintain her agency capacity, and that's okay. We haven't violated any duties, there's no problem in doing that, right? And I'm maybe not the best example because I am also the employing broker, and so I have some supervision responsibilities, and so that gets a little weird. So maybe a better example would be if Jerry has the seller and Liz has the buyer, and they're both agent and they're working in an agency capacity, right? They can do that. That's not a problem. Totally okay. Now, not all states operate that way. Many states have these, laws that say, oh, anyone in the brokerage has the same relationship with the parties, right? And so thereby you would be acting as a dual agent if you brought the buyer on one of the brokerage firms listings. And dual agency is not allowed in the state of Colorado, okay? So if it's an in-company transaction with different brokers, that's okay. You can maintain those relationships and that's fine. If there's an in-company transaction where there's only one broker involved, right? So Liz has a listing and she's the seller's agent, and someone comes through her open house and says, hey, Liz, we love the property, we'd like to buy it. Well, at that point, Liz cannot maintain an agency relationship with the seller and treat the buyer as an agent or even treat the buyer as a transaction broker, right? Her only options are either treat the buyer as a customer and maintain my seller's agency relationship, switch into transaction brokerage and treat both as a transaction broker, or even though this would probably never happen, feasibly, it could, you could terminate your listing agreement with the seller, treat the seller as a customer, and treat the agent as a buyer's agent, okay? Your other option is refer the buyer out to somebody else who's not a member of your team, okay? So if Liz were to call me up and say, hey, Jesse, I'm a seller's agent for the seller. I have this buyer, they want to purchase the property, but they really want to have someone represent them as a buyer's agent. Would you be willing to help? Then yes, I would. Now, maybe Liz doesn't want me to be the buyer's agent, right? She wants to pick the dumbest person in the office and have them represent the buyer as the buyer's agent. But you get the point, right? And just so you know, I'm not that hard to work with, I promise. Have I done deals with any of you guys? Brandy's not on this call, so that's good.
Oh my God, he's the worst. I'm telling all of you right now.
Did one, and that was the easiest deal ever. So yeah,
I know it was.
yeah, Brandy and I had a little bit of a disaster, but that was before she worked at KW, so I took advantage of her. So, okay. Buyer's agent. So if that buyer agency box is checked at the top of page 1, then the parties agree that the following applies. Now, these 4.3.1.1 and 4.3.1.2 have flip-flopped. It used to be that this was the standard and this was the option. Now we've got this is our standard and this is the option if this box is checked, right? And so what this says is, by default, the parties agree that I will be a buyer's agent for you unless I have a brokerage relationship with both, in which point I have the ability to switch into a transaction broker status, okay? So I'll treat you as an agent and they treat seller as a customer. Customer is a party of the transaction with whom I have no brokerage relationship. But if I deliver to you a written change of status, right, and that's important, we still have to do a change of status. We can't just say, oh, by default, I had the right to switch into transaction brokerage. You did, but you have to deliver to them a written change of status, changing your status from an agency relationship to transaction brokerage. That is how you become a transaction broker, right, is by actually delivering the written change of status form, notifying them that you have a brokerage relationship with the seller, and therefore you're now going to switch into transaction brokerage, okay? Unless, of course, you've checked this box, and if this box is checked, then it says, I'm going to treat you as your buyer's agent, and I must treat the seller as a customer regardless. So then your option would be, okay, I can refer the seller out to someone else if they want to have a brokerage relationship with somebody. Otherwise, I treat them as a customer, meaning essentially it's a FSBO, right? Now, if the seller has their own brokerage relationship with some other outside broker or whatever, then obviously this is not going to come into play, okay? Section 4.3.2, if the transaction broker box is checked at the top, or if neither box is checked, then you will be their transaction broker, right? And you have to do those duties described here in section 5, and you have to facilitate the transaction without being an advocate or an agent for either party. Now, what you'll notice is it doesn't say that you can't advise the parties. And in fact, what it does say when we get down here is that you have a duty to advise the buyer regarding the transaction, and you have to advise them to obtain expert advice about things that are beyond your expertise as a broker, okay? So don't get those mixed up. You cannot be an advocate for them or an agent for them, but you still have to advise them regarding the transaction, okay? So you still have to keep them fully informed and all that stuff. We'll cover those here in just a second. But if seller and buyer are working, are both working with the same broker, then broker just continues to function as a transaction broker. You don't need to do a change of status because you're already a transaction broker, okay? So any questions on section 4? Okay. So section 5 is where we get to our duties, and these are called uniform duties because these are duties that apply whether we are acting in an agency capacity or a transaction brokerage capacity. So we have all of these duties regardless. And then if we are acting as a buyer's agent, we have these following 3 additional duties, which we'll talk to. But we have to do these no matter what. And there was a lawsuit recently that I think made it all the way to the Colorado Supreme Court. And effectively what it was, that Vizzy is the lawsuit, V-I-Z-Z-I, I think is how you spell it. And Vizzy was a listing broker that was doing limited service listings, entry only listings, right? Where he said, hey, for a flat fee, whatever, $1,000, let's say, for a flat fee of $1,000, I will put your listing in the MLS. And then once it's sold, I'll close it out in the MLS. But I'm not going to deal with any agents. I'm not going to arrange showings. I'm not going to present offers. I'm not going to advise you as far as any offers go, anything else, right? And as part of his listing agreement, what Vizzy was doing was he was striking through all of these, right? And having the buyer's initial and say, hey, I'm not going to perform the terms of any written or oral agreement with you. Strike it out, right? Buyer's initial here. Not going to present offers to you. You're going to get those directly from the other brokers. Strike through that, right? And initial here. I'm not going to disclose any adverse material facts that I know about. Strike through that, initial here, right? And he just struck through everything, right? And effectively said, the only thing that I'm going to do is I'm going to put your listing in the MLS. And then when it closes, you're going to let me know. And then I'm going to update the MLS, okay? And the Colorado Supreme Court said, hey, based on the way that the Brokerage Practice Act is drafted, and Brokerage Practice Act is what allows us to act as real estate brokers, right? Based on the way that the Brokerage Practice Act is drafted, you can't waive these duties that you have to the public. You have to do at a minimum the duties in Section 5. Now, you don't have to do these duties in Section 6 unless you've checked the box at the top, in which case you also have to do those, but you cannot waive your obligation to do any of these duties, okay? And so if you're bored one day, go read the Vizzy lawsuit and, they'll spell all that stuff out for you. But it says that you have to do these uniform duties, whether you are a transaction broker or a buyer's agent, okay? And real quick, just in case anyone has this bright idea that says, well, then I won't be a transaction broker or a buyer's agent. Let's look at this from the seller side, right? Say, hey, I'm not going to be a transaction broker for the seller, and I'm not going to be a seller's agent for the seller. I'm just going to treat the seller as a customer and enter their listing into the MLS. Nope, you can't do that either. You have to have a listing agreement in order to put the property in the MLS, right? Your listing agreement needs to be on this form. There's no way for you to just enter them into the MLS and not do any of these duties, okay? So Section 5.1 talks about the minimum duties that we must do. So, and they all kind of fall under this umbrella of exercising reasonable skill and care for the buyer. So 5.1.1 says we have to perform the terms of any written or oral agreement with the buyer. Okay, so the weird part is that there's a section later on in this contract that says any agreements, whether written or oral, have been merged into this agreement, right? And they've been written into this agreement. And that gets a little bit weird. I know most of you guys have heard about the squirrel thing, right? And we won't cover it here today, but had a broker where they agreed to do some stuff outside of the contract that was never written into the contract, right? And fortunately, we relied on the other section of the contract that says any written or oral agreements have been written and merged into this agreement, right? And so they could have still said, well, your broker violated duty 5.1.1 of performing the terms of any oral agreement because it was undisputed that an oral agreement had been made, okay? And therefore our broker would have been in violation of the terms of this contract. It would have been in default, right? But we relied on this other clause, and fortunately they opted not to ever get an attorney. And so that deal just ended up going away. but it was $37,000 worth of damage due to squirrels getting in through the fireplace. Okay, so fortunately that one went away for us. But the bottom line is be careful about what you're agreeing to, orally. Get it written, everything agreed to in this contract so that there's no question as to what the agreement was between you and your buyer. Okay. 5.1.2 says we have to present all offers to and from the buyer in a timely manner, even if they're already a party to another contract for the purchase of the property. So if someone calls you and says, hey, are the sellers open to, obviously we're talking about the exclusive right to buy, but let's say you're on the listing side and someone says, hey, is the seller open to a backup offer? And you say, no, we're pretty good. We're under contract, we're a week out from closing. And then they end up sending over an offer anyway. Well, you can't just sit on it and say, well, I'll call you if our current deal falls apart, right? You still have to present it in a timely manner. Now, timely manner is not defined. However, it should be at your first reasonable opportunity, if nothing else, to email it to, in this case, the buyer, right? Which is a little bit weird because typically the buyer writes the offers, but this could apply for counter offers, amendments, objections, resolutions, any of that type of stuff, right? So presenting any of those to your buyer in a timely manner, even if the buyer, is already a party to the contract to purchase, whatever, another property or something, okay? So it is feasible that a seller could throw out effectively a reverse offer, right? So, and I've had it happen, and I've also done it before, not in this market, but previously what had happened was, you have a buyer who writes an offer on a property and they're, $25,000 apart from the seller, and the seller says, no, we're just going to reject it, right? And so a week goes by, seller doesn't get any other offers, and they go, hey, let's reach back out to these buyers. Let's just draft a reverse offer where the seller drafts it. They put the buyer's names in there because they already have the buyer's name, and they say, hey, come up 10 grand and, we've got a deal. And so instead of writing that offer at 375, they write it at 385 and send it over to the buyer. Now the buyer's agent has to present the offer to the buyer. Okay. So it is possible. It's kind of weird, and it doesn't happen in this market very often, but that is a real thing. Okay.
So Jesse, if you get an offer and they don't tell you, they verbally say, hey, I have a buyer, they may be interested in putting an offer in, they don't tell you an amount, and they don't submit anything, you still obligated to tell your sellers that they're possible or no?
Yeah, so good question. And one of these duties that we'll talk about here in a second is that you have to keep your client fully informed, right? And so keeping them fully informed is like, hey, I got a phone call from so-and-so today, and they have a buyer who's asking about, backup offers. What do you want me to tell them to go pound sand because we're a week away from closing? Or do you want them to submit the backup offer anyway, right? And in most cases, probably they say, hey, just tell them we're close. We'll call them if if something falls apart, and that's okay. But you should still keep your client fully informed. Now, there is another lawsuit in the state of Colorado that was effectively what happened was a deal was under contract, right? And a buyer's broker calls up the listing broker and says, hey, I've got a buyer. They're interested in this property. And although they never drafted it on, real estate commission forms, they effectively hammered out all the details via phone. And they said, hey, my buyer would be interested at this price instead of that price, which is more than what they were currently under contract for, right? And so the broker's like, okay, yeah, that's fine. Like, we'll talk about it when we get there. Well, in the meantime, what happened was buyer number one ended up submitting an inspection objection or an appraisal objection or whatever. Well, the listing broker had never informed the seller that, hey, there's this other potential backup buyer. Even though they didn't submit a backup offer on paper, we've kind of hammered out some terms, right? And it's better than offer number one, okay? So seller not knowing about this potential backup goes, okay, hey, buyer number one, they objected to this, let's get it resolved and move forward. And so they, listing brokers like, okay, good, we'll get it resolved with buyer number one. Well, The problem is listing broker was also working with buyer number one. And so why do you think broker never told the seller about buyer number two? Because they were working with a different broker, and broker wanted to double in this deal, right? And if he could get the issue resolved with buyer number one, then he's, double ending that deal. He's making double the commission, right? And if I just don't tell the seller about buyer number two, I can keep this one going and get them to, agree to, whatever, meet in the middle on inspections or appraisal or whatever, right? And then I line my own pockets at my client's expense. Okay, that's a problem. So even if they don't write that offer on paper, right? Effectively, what this lawsuit said is, hey, broker, you had an obligation to go get it, right? You practically hammered out all of the details. You have an obligation to go get that offer and get it in writing. You certainly had an obligation to keep your client fully informed, right? And you failed to do that. And so this broker was found to be, in violation of his duties to his client. Okay. So you still have an obligation to keep your client fully informed. Yes, you should tell them about it, even if it doesn't ever come in. And then if they advise you like, hey, yeah, why don't you go secure a backup offer from them? Great. And if they go, no, that's okay. We're going to, we're only a few days from closing, or, hey, no, we really don't want anyone else in the house. And so we don't want any other offers or whatever. And then that's all fine and good, but at least it's their decision and it's not your decision. Okay. You have to disclose to buyer any adverse material facts that are actually known by you, the broker. Now, in most cases, you probably aren't going to know a lot of adverse material facts about the property. Now, maybe if you can see that there's some kind of, damage to the property, or if you know that there's going to be dairy going in across the street that's, it's going to smell like cow crap for the rest of their life, or whatever it is, right? Like, then go ahead and disclose those. Now, one thing that is important is that you do not have a duty to conduct an independent inspection of the property on behalf of the buyer, right? And you don't have to verify, the accuracy of any statements that were made by the inspector or any other, independent contractors or anything like that. And you want to be a little bit careful about what you are advising the buyer, right? Like, you don't want to look at a home and go, oh, yeah, like, I don't see anything wrong with this property. Well, that's a really terrible thing to tell your buyer, right? And if you happen to be a home inspector as well, I probably would not inspect your own listings, because you're just increasing your liability exponentially, right? So be careful about that. You don't have a duty to do those things. Obviously, if you do know that there's an adverse material fact, you have to disclose that, but you don't have an obligation to go search out adverse material facts. Okay. 5.1.4, you have an obligation to advise the buyer regarding the transaction, whether you are a transaction broker or a buyer's agent, doesn't matter. Okay. You have to advise them regarding the transaction. You have to advise them to, get expert advice or opinions about things which are outside the scope of your expertise as the broker. Okay. So again, I know everybody wants to go above and beyond and, do right by their clients, save them money by not having to, have them go talk to an attorney or whatever, but stay in your lane, right? Especially if you're a transaction broker, you don't have those duties, those 3 additional duties in Section 6, right? Just advise them to go talk to an attorney, okay? If they choose not to go talk to an attorney, then you shouldn't be the cheap, free legal advice because you're not licensed to practice law, okay? So advise them to consult a CPA or an accountant or an attorney or whatever they need to, okay? You have to account in a timely manner for any money and property received. So first of all, don't receive any property ever. You don't want to take somebody's wedding ring as earnest money down, as a form of their earnest money payment, okay? If you are going to accept earnest money from your buyer, then you need to make sure that you're turning it over to either the title company or to, you know, in some cases, the brokerage firm will hold the earnest money themselves. And so when you're turning that over, you need to get an earnest money receipt that shows, hey, I actually, you know, dropped this off where I was supposed to, and I've got someone's signature on it saying they now have it, right? We as a brokerage firm do not hold earnest money. Some do. We do not. Okay, so don't make Keller Williams Realty Partners or Keller Williams Action Realty or whatever office you're with. Do not make them the earnest money recipient. We're not going to hold that earnest money, and you shouldn't hold it either. Okay. Be careful about where you're delivering the earnest money to. I had one that was supposed to go to Remax, right? And I ended up taking it. I knew who the closer was because I've worked with this agent before. The closing instructions have the closer's name on it, right? And it was at Unified Title. And I'm like, great, I'm just going to take it over to Unified. Well, I took the check to Unified, and it was like Friday at 4:45 p.m., right? And Unified is like trying to get everything wrapped up and done for the day. And so they didn't look at the check. They just scanned it, put it on the earnest money receipt, signed for it, sent me out my way. And then on Monday, I get a call, and they're like, hey, we got this check for Remax Alliance that you delivered to us. What, do you want to come pick it up? Well, in the meantime, we had missed our earnest money deadline to get the earnest money to the earnest money holder because it was supposed to go to Remax. It wasn't supposed to go to Unified. And so technically, my buyer was then in default of the terms of the contract. And, you know, fortunately, seller, you know, signed an amendment and everything else, and we just proceeded to close. So no harm, no foul, but just know that technically the buyer is in default if they miss getting the earnest money to the earnest money holder by the alternative earnest money deadline. And if the buyer's in default, what is the seller's remedy in the contract to buy and sell? Assuming you don't have specific performance checked, what's the buyer's or what's the seller's remedy for a buyer's default?
Earnest money.
Yeah, so they can elect to treat the contract as canceled and keep the buyer's earnest money, even though the buyer hasn't even turned it in yet, even though they haven't even tried to get inspections scheduled or line up their financing or do the appraisal, review the title work. Your buyer's already in default and they haven't even turned the earnest money in. And it doesn't matter whether they've turned it in, they're still on the hook for it, right? So not a good position to put your buyers in. Make sure you're getting that earnest money delivered to where it's supposed to go by the deadline. Okay. 5.1.6, you have to keep the buyer fully informed regarding the transaction. So again, we just talked about a case in Colorado where a listing broker was not doing that. And in that particular case, the listing broker was not keeping the buyer or keeping their seller, right? This is on the other side, but same thing applies. In that case, they were not keeping the seller fully informed in an effort to line their own pockets, right? Now, that doesn't necessarily always have to be the reason why you may elect not to keep your client fully informed. There are certainly other times where brokers are just pieces of crap and they drop the ball. Maybe it's an accident, but in most cases, it's because they're pieces of crap. And, they are just not keeping their clients informed regarding the transaction, right? They're getting terrible reviews because they're not talking to their clients, right? Whatever. One thing that I recommend you guys do is just put something on your calendar for either like Friday afternoon or Monday morning or Monday afternoon or something, where even if there was nothing that happened over the course of that week in your transaction, you still just send your clients a note that says, hey, just want to let you know everything's still moving along, nothing significant to be worried about. Let me know if you have any questions, right? And if you can prove that you're doing this, obviously you still need to keep them informed when there are other dates and deadlines and other things that are happening during the week. But if you're keeping them advised, even when there's not stuff going on, it still helps them feel like, oh, hey, yeah, my broker's great. They're keeping me informed. They're keeping me in the loop. Even when there's nothing going on, right? I still get a quick little note that lets me know everything's still moving along like it should. There's nothing I need to be worried about, right? So it's one thing that I would recommend. You don't have to, but just a good practice to do to make sure that your clients feel like you're still involved in the deal. You're still looking out for them. You didn't forget about them. You didn't forget about something that might be coming up in the transaction. So do that. I think it's a good practice. Okay.
So Jesse, you're saying to do that once you've got them under contract through a CRT contract to buy and sell?
Yep.
Okay.
Yeah. I mean, if you have if you have a buyer, right, and your buyer hasn't looked at any properties or anything else, like, yeah, I'm not sending out weekly updates. You know, I have them on an automated search, which is sending them listings. But I'm
Right.
not checking in with them, and you know, I shouldn't say that. I'm not checking in with them every week
Weekly.
like I am with all of my, you know, deals that are under contract, right?
Okay. That's what I thought you meant. I just wanted to clarify.
Yeah, good question.
Thanks.
Other questions about things we must do? Okay, so 5.2 talks about things that we must not disclose as part of the transaction, right? Again, this applies whether we're a transaction broker or a buyer's agent. So we can't disclose that the buyer is willing to pay more than the purchase price that they offered for the property. Now, again, in today's market, right, maybe that seems weird to you, but what happens if, you know, you're trying to be competitive and you're trying to lock down a transaction with them, and you're like, hey, you know, my buyer, here's our offer, and it's a great offer. It's $40,000 over list price. If that's not the best, you know, buyer will go up. They'll increase their purchase price. Well, do you have the buyer's written permission to do that? Because if you don't, what's to stop the seller from just saying, okay, if the buyer's willing to go up, let's make it $60,000 over list price. I don't have any other offers on the table, but if you're dumb enough to tell me, like, let's go up to 60,000, right? So you got to be careful about how you're doing that, right? And it doesn't always just come out as like, hey, here's our offer for 550. Buyer's willing to go up to 575 though, right? And obviously we know that, but just be careful about how you're presenting the offers, right? If it's in the offer, great, let the offer stand. And if it's not in the offer, then don't mention it, okay? If there's potentially some other things that may come into play that, you know, you discuss with the listing broker, right, on behalf of the buyer, but get the buyer's written permission if you're going to disclose that, because by default, you have no ability to disclose that they're willing to offer more than what they've offered for the property, okay? You can't discuss the buyer's motivating factors. Again, potentially, if you have the written permission to do that, then great, do it, right? But sending over an offer to the listing broker and saying, hey, my buyers are under the gun, they've got a lease that ends at the end of May, they got to find a place, they got to lock it down, right? This is the perfect house for them. You've just disclosed your buyer's motivating factors, right? So unless you have the written permission to do that, don't do that, because then the buyer could come back to you after the fact and say, hey, you disclosed my motivating factors. It caused me to have to pay more for the property than what I really wanted to, and therefore you're in violation of the terms of this contract. And we believe that you have not earned your commission under this contract since you violated your uniform duties. Okay.
So Jesse, how do you go about getting their written permission to do so?
Yeah, just an email typically is good. I mean, you could certainly do a text, but text could disappear easy, and it's hard to you know, have proof of that unless you're screenshotting it and then emailing it to yourself. Much easier to have a paper trail if you're actually, you know, getting emails. And then obviously don't delete those emails, although, you know, are there ways to get emails back that have been deleted even if they've been removed from your trash? Yes, Big Brother has access to your emails. Are you ever going to be able to get that back? I don't know, right? So if it's important, if it's part of a transaction, you know, create folders or some type of system that you use or whatever that you know, like, hey, I'm not going to delete this for at least 4 years, right? So yeah, usually email is the best way. You can certainly get it in the exclusive right to buy here. You could come down to additional provisions, right, and say, hey, you know, I have the right to, you know, discuss your motivations, particularly your motivation that your lease is ending. Okay, you could write something in there as well, but just an email is okay as well. Okay.
Thanks.
You cannot disclose the buyer will agree to financing terms other than those offered, right? So again, this is not a big issue that we're seeing a lot of, you know, problems on. Like, you know, usually you fill out the financing terms in the offer itself, and that's pretty self-explanatory, right? Why would you disclose anything other than what's offered there? I don't know. And then this one's kind of interesting. So you can't disclose any material information about the buyer unless disclosure is required by law, or failure to disclose that information would constitute fraud or dishonest dealing. So what's unique about this is that you have an obligation to disclose adverse material facts about the buyer, okay, which is not the same as your obligation to disclose to buyer any adverse material facts that you know about, like the property, for instance, right? But you have to disclose adverse material facts about the buyer of which you are actually aware. And so let's say that the buyer goes, well, hey, because of the market, right? Like there's 5 houses on the market this weekend, and I just got to make offers on all of them to see if I can get one of them to stick. Well, in doing that, unless your buyer has the financial ability to close on all 5 of those properties, then there's some serious disclosure that needs to take place with respect to the buyer's financial condition. It says, hey, listing broker, we have offers out on 5 properties. Buyer can't purchase all 5 of them, right? And probably in addition to disclosing, you need to have a mechanism in your offer whereby the buyer has a right to terminate one of them if multiple offers get accepted. Now, if the seller knows that you're writing offers on 5 properties or 3 or whatever it is, right? Like, you think they're going to work? You think that's going to make your offer attractive to the seller? I mean, probably not. It's going to be a turnoff to a lot of sellers. And so it's not really something that I would advise doing. And if you are going to do it, you need to make sure that your buyer is okay with you disclosing the fact that, hey, my buyer can't perform the terms of this contract if any of these other contracts get accepted, okay? And again, I would probably create a mechanism whereby you have a right to terminate one of your contracts, not using one of the other deadlines in your contract, right? Because none of those deadlines in the contract to buy and sell say, buyer, you have a right to terminate because you wrote multiple offers and both got accepted, or 2 or 3 or 4 got accepted, right? That is something you would have to draft into your contract to give them that right. Otherwise, they would be in default. That makes sense to everybody? And it's not a good practice. It's not one that I want to see you guys doing, okay? All right, so those are what we must not disclose, right? 5.1 was things that we must do, what we must not disclose. And then there's some other stuff that really doesn't fit into either one of those. 5.3 just says, buyer consents to the broker's disclosure of confidential info to the supervising broker or the supervising broker's designee so that you can be properly supervised regarding the transaction. Now, again, this gets a little bit weird where, you know, your supervising broker is on the other side of the deal, right? In many cases, what we would do is then we would assign, you know, specifically for Loveland, let's say I'm the listing broker, right? We would assign a separate supervising broker for you, and potentially multiple supervising brokers for you so that you have multiple people to bounce stuff off of. What's kind of weird though is that I can technically still be your supervising broker on your deal where I'm acting as, say, a seller's agent and you're acting as a buyer's agent. I just have to not use that confidential info to my client's benefit. So effectively, it's like I have to keep it confidential myself. So really weird situations, but that's a real thing, okay? 5.4 is fun. So you may show properties in which your buyer is interested to other prospective buyers as well without breaching any duty or obligation to the buyer. You're not prohibited from showing competing buyers the same property and from assisting competing buyers in attempting to purchase a particular property. Okay, now there's some real debate amongst Section 5.4 in the legal community, right? And so let's say that I have an exclusive right to buy with buyer number 1, and I have an exclusive right to buy with buyer number 2. And in both of those contracts, I am acting as a buyer's agent for those buyers, okay? So I have these extra duties in section 6 to promote the interests of that particular buyer with the utmost good faith, loyalty, and fidelity, right? And so if I am a buyer's agent in particular, and two buyers want to see the same property, okay, you go show it to both of them, and now they both call you up and say, hey, Jim, I'd really like to submit an offer on this property. What the heck are you supposed to do? And I'm not just asking Jim, I'm asking anybody. So what do? You're a buyer's agent for both buyers, and they both call you up, say, hey, let's look at the property. After seeing them, they say, hey, we want to make an offer on this property. Can you truly promote the best interests of two different people with the utmost good faith, loyalty, and fidelity?
No.
I think it's very difficult to do that, right? I mean, it's almost the same as acting as a dual agent, where you're saying, hey, I'll be a seller's agent for the seller and a buyer's agent for the buyer, right? Well, how can you treat two separate parties, both with the utmost good faith, loyalty, and fidelity, when they're trying to pursue the same property, right?
You had that happen, right, Jesse, and you let them work that out, right?
Yeah, so fortunately, my situation was a little bit unique. Just so if you guys haven't heard it, so what happened was one set of buyers calls me up and says, hey, can we see this property at 5:30? And I'm like, yep, let's go take a look. So I schedule a showing, and so buyers, set of buyers number 2 call me and they say, hey, can we go see this property at 5:30? And I'm like, oh, well, I can't do 5:30, and I didn't tell them why, right? I'm like, can't do 5:30, but I can do 6:30. Does that work for you? Thinking like, oh, that'll give us plenty of time to see the property with buyer number 1 starting at 5:30 and get out, so that there's no, inkling of it looks like I'm playing both sides of this thing, right? Well, I knew, because both sets of buyers and myself, we all went to church together, so I know that they know each other too, right? Not only did I know both of them, they knew each other. And so I show up at 5:30, right? And I'm showing buyer number 1, and lo and behold, somebody just walks in while we're like in the basement, and I'm like, what the heck? Who's in here? Right? And so walk upstairs, and it turns out it's buyer number 2, and they saw my car outside, and then they saw our mutual friend's car outside. They're like, oh, well, let's all look at it together, right? And then both of them were like, okay, we're interested in the property. And I was like, okay, time out. You guys obviously know what's going on at this point. You know that I've showed the property to both, and so both of you need to get together, and you guys tell me who's going to make the more aggressive offer on this property. And so they actually worked it out between themselves, which is super weird, and I never typically would advise you to have your buyers talk to each other about who wants to make a more competitive offer. Super weird. It just so happens in this case it worked, right? But what do you do if they don't know each other, right? And they both want the property? What are you supposed to do? What do you think? What would you do?
Go with the person that's making the best offer.
Well, yeah, I mean, so it's easy enough to say that up front, right? But you really don't know who's going to make the best offer potentially, right? And so you say, okay, let's hammer out the terms, and they go, okay, here's our offer. And then what are you supposed to tell them? What are you supposed to tell buyer number 2 who doesn't make the best offer, right? Hey, I'm really sorry, but I have another exclusive right to buy. These other people want to buy the property too. Your offer is not as strong as theirs, so I'm going to refer you out to somebody else, or we need to go pursue a different property. Like, that's tough.
Why would you do that? You don't have to disclose that to them. Isn't there a section earlier in the contract that says you're allowed to work with competing buyers on the same property?
Yeah, but
why would you put yourself in that awkward situation? Just say another offer got accepted.
Right. So there is a section that says you can work with buyers on competing properties, right? But particularly if we're talking about being an agent for the buyer, 6.1 says we have to promote the interest of our buyer with the utmost good faith, loyalty, and fidelity. So is that being loyal to your buyer with whom you've agreed to be a buyer's agent? And are you treating them with good faith and fidelity?
No.
And this is where there's the debate, right? Of, well, maybe that makes sense if you're a transaction broker and you don't have that duty of treating them with the utmost good faith, loyalty, and fidelity. But if you're a buyer's agent for both, right? Well, now you have effectively competing duties. That does it override your, ability to work with different buyers on the same property, or does it not? I mean, they're duties that are in addition to those listed in Section 5, and really they it's almost like they supersede in a certain sense your duties in Section 5, right? And so it just makes it very weird and awkward when you're in this situation. So hopefully you don't have it happen, right? And the bottom line is I don't have a good answer for you, right? Maybe you, rather than wait until each buyer tells you the terms of what they want to, what they want to offer, you might have some kind of idea as to the financial, qualifications of them, right? Maybe one buyer's 20% down and one is 3.5%. And so maybe you call up your buddy and say, hey, like, I need you to be a buyer's agent for these guys, specifically for this one property at 123 Main Street. And if it works out, then you pay me a referral agreement. And if it doesn't work out for them on this property, I'll represent them on future properties, right? And then you go to bat for your 20% down client. Like,
So you would just do a exclusive right to buy just for that one house
well, I would probably just do a referral agreement with another broker.
with another? Okay, yeah.
Right? And then let them do the exclusive right to buy for that one property, whereby they're a buyer's agent for that one property, but not.
But that's the agreement you would make for the referral, right? Just the one property.
That it's only
Okay.
for one, and it would need to be spelled out and be clear in there that, hey, if this one property doesn't work out, I'm working with these people, right? And the only reason I'm doing this is because I have a competing interest. Okay, but yeah, really bizarre, situation to be in. So hopefully you guys don't find yourself in that position, because there's truly not a good workaround for that, and you're opening yourself up to someone saying, hey, you violated your duties to me as my buyer's agent. Now, on the flip side, right, let's say rather than being a buyer's agent for both, let's say that you have a buyer's agency agreement, right? With one, you're treating as a buyer's agent, the other one you're treating as a transaction broker. Well, in that case, what do? I think you treat your buyer, the one you have the buyer's agency agreement with the utmost good faith, loyalty, and fidelity, right? Now, I don't think you can, you still can't advise them of, the terms of this other offer that you have, right? But maybe you at least say, hey, transaction broker buyer, like, I've got a competing interest, right? It's easier to explain that away. I have a duty to someone else where, because they've signed an agency agreement, that I have to treat them with the utmost good faith, loyalty, and fidelity, right? And so my duties to them are going to cause me to have to, refer you to somebody else. And then, you probably are going to have to tell your, buyer's agent client, hey, you're going to have to bring your offer up. Like, again, you can't disclose the terms of your other offer from, this prospective transaction broker buyer, right? But if you know that there's another potential offer out there that could potentially beat them, and you have an obligation to treat them with the utmost good faith, loyalty, and fidelity, you got to tell them. Like, that's still a little bit weird position to be in, right? So I think it's easier to explain away when you've got a transaction broker party on one side, you're treating the other party as a buyer's agent. But what about when you're a buyer's agent for both? Man, that's tough. Refer them. Whoever is less qualified, I would refer them out. Honestly, is my advice to you there. Okay. Let's see. 5.5, you're not obligated to seek other properties while the buyer is already a party to the contract to purchase. So you're already under contract. You don't have to, like, let's say that tight market, buyers just trying to get anything under contract, right? And they finally get one, and they've had to kind of give up kind of what they're looking for and take something that isn't quite up to their expectations, right? And so you finally get them under contract, you turn off their auto search, which I always do right away, turn it off, because inevitably what's going to happen is you're going to go under contract and then something's going to hit and they're going to see it and they're going to go, whoa, I like that one better. I want to go pursue that one. Okay. So once they're already under contract, you are no longer obligated to seek other properties for them. Even if it's not quite what they were hoping for, right? Now, doesn't mean they can't do their own searching, but you don't have the obligation to continue to seek out other properties that fit their needs. Okay. So I think that's pretty clear. Any questions on that one? Okay, we talked about 5.6. You don't have to do an independent inspection of the property, and I wouldn't. There's a broker in the Fort Collins office who measures all of his own properties as well and uses that as his square footage, and I highly, highly recommend not doing that. I just think you're taking on a lot of liability by measuring a property, doing independent inspections of the property, right? Like, that's outside the scope of real estate brokerage, and you just shouldn't do it. There's better sources for square footage. There's better sources for, inspections, all that other stuff, right? There's no reason for you to take on those liabilities. You're just opening yourself up to lawsuits. Okay.
Jesse, I have a quick question on that.
Yep.
So the new tool that Iris is offering with that flow plan, which is where it's the app where you walk the property and upload that and they generate the floor plan for you. What are your thoughts on that?
So I don't mind generating the floor plan, but I would be very hesitant about using any type of square footage figures that are coming off of there. I mean, again, how accurate is it? I have no idea. But what I don't want is something that over represents the square footage. And then lo and behold, buyers like, hey, wait a minute, like, this house is 1,200 square feet instead of 1,500. Like, how the heck did you get that? Oh, I just relied on the app, right? Well, why did you rely on the app if it wasn't, if it wasn't a trustworthy app? Like, have you tested it before on homes where you actually know the square footage to be, a particular square footage? I don't know. How proficient is it at measuring curved walls? Like, I don't know. Right?
I don't either. It's new. So I was just wondering, yeah.
So the floor plan feature might be cool, and might give them a good idea of like, this is roughly what it looks like. But again, I don't want to rely on it, right? Now, so I use a service to measure my listings in most cases, not all, but in most cases. I'll have Appraisal Dimensions come out and measure the property. And Appraisal Dimensions, they're licensed appraisers, and they'll actually come out and they'll measure and they'll do floor plans and everything else, right? If I don't do that, then typically I just rely on the assessor's figures, and those are good enough unless I have a reason to believe that they're different. Then who cares, right? The other thing that you could potentially do, and this is just something that you should ask as you are listing properties is, hey, do you have any appraisals from this property from when you purchased or when you refinanced? Because the appraiser is supposed to do their own measurements, their own floor plans, and they're typically towards the very end of the appraisal. And so if they have an appraisal on file, then you can compare that and you can say, hey, here's the number that you have from the appraisal with actual floor plans, right? Versus here's the number on the assessor's office. Probably the one that got measured by the appraiser is more accurate because the assessor's office is off all the time. And in many cases, the appraiser measured piece is going to be bigger than what you see in assessor's records. That's not always the case. But if there's an extra 200 square feet there from the appraiser compared to what's in the assessor's records, right? You're effectively adding value by getting an extra 200 square feet, it already existed. But if you had listed it at a lower price based on a smaller home, you've done your client a disservice, right? And so I will always ask, hey, do you have a prior appraisal, whether it was from when you purchased or from a refinance or anything else, right? And the refis don't always have the floor plans, but the purchase should always have the floor plans. And so, good thing to check, and then you've already got the floor plans as well. But as far as flow plan, I don't know. It's a cool tool, and that's about the extent of it for me.
Thank you.
Yep. Let's see. So 5.7, you must disclose to any prospective seller any adverse material facts actually known by the broker, including but not limited to those adverse material facts about the buyer's financial ability to perform. So again, we talked about this as far as submitting offers on multiple properties, which you really shouldn't do. Is there some caveats there? Yeah, potentially. I mean, if they're qualified to purchase multiple properties, then do it. If you disclose, can you do it? Yes. Is it a good idea to do it? No. And you need to really advise your buyer as to the pros and cons of doing that, so that they understand the pros and cons of doing that. And again, you probably are going to want to have a mechanism in the contract whereby you can terminate if more than one offer gets accepted. Now, that's not really a clause that you should be drafting. Okay, I'll just throw that out there. If you think that that's a good idea and your buyer wants to do that, then tell your buyer to have an attorney draft a provision that would allow for that to take place. Okay, because I don't want you taking any part of that. You're just increasing your liability exponentially by doing that. Okay. That includes as well whether the buyer intends to occupy the property as their principal residence. I think that's a complete joke. I hate the fact that that's even a thing, right? Because sometimes working with investors sucks, because the sellers are like, well, I don't want my property to be turned into a rental. It's like, okay, so what happens when buyer, that's going to own or occupy the property is addicted to meth, and they turn it into a meth lab? Like, I could have just turned it into a rental, and instead you let it get destroyed by a meth head. Like, or what happens if, buyer number one occupies the property and then they sell it to an investor or a meth head or whatever, right? Like, if you have no control over what happens to your property after closing, who cares who it gets sold to? I get that you have your childhood memories from the home and everything else, but what if they scrape the property? I don't know, right? Do they have a right to do that? Yeah. Can you stop them? Probably not. So make the best decision, right? I don't even typically, advise that my clients consider whether the property is going to be occupied as a principal residence or not, right? Make the best decision based on purchase price and terms and all that other stuff. Who cares who's going to occupy the property, okay? And then you get like, well, we're good friends with the neighbors and we don't want it to turn into a, college rental and whatever else. Like, I don't really care, right? Because what happens if the buyer who's the owner occupant is a complete dirtbag and lets it go to waste anyway? So again, I just think any argument that you could make for a seller to make a decision based on the occupancy of the property, I just think it's bogus, right? That being said, certainly there are things that buyers may want to do to try to make their offer more attractive. Now, you can't lie about that, because again, that's considered to be an adverse material fact, right? But one of the things that we'll talk about on this May 7th class, did I mention that already, by the way? Did I mention the May 7th class in this class? Yeah. So one of the things we'll talk about in the May 7th class is some things that your buyers can do to be a little bit more, not really aggressive. I mean, we'll talk about that too, but make their offers more attractive, or some things that can be done outside of the offer to help their offers get accepted, right? And so, working that whole, tugging on the heartstrings thing, right? Hey, this is a beautiful property. We're going to occupy it. We're going to take good care of it, yada, yada, whatever. Like, use it to your advantage as a buyer, but as a seller, don't be fooled, okay? 5.8, buyer understands the buyer is not liable for broker's acts or omissions unless they've been approved by the buyer. That makes sense. Okay, real quick, we'll end with section 6 and then we'll talk about compensation next week. So if you have that buyer's agency box at the top of the contract check, then you agree that you're going to be the buyer's agent, and you will have, in addition to all those duties in section 5, you're going to have these 3 additional duties. So we talked about promoting the interest of the buyer with the utmost good faith, loyalty, and fidelity, seeking a price and terms that are acceptable to the buyer, right? That makes sense. And then counseling the buyer not only as to any adverse material facts that you're aware of, but also any material benefits or risks of the transaction that are actually known by the broker, right? And so if you know that, you know, Walmart is the buyer, but Walmart was buying it under a shell name, right? Well, that may be a benefit to your seller. Again, but we're looking at this from the seller side, but same thing, you know, applies on the buyer side as well. If you know that Walmart is buying your farmer's piece of land, even though they bought it under XYZ LLC to try to mask the fact that Walmart is your buyer, do you think that that's a potential benefit for your seller in that case, if you're representing the seller? Yeah, because what are you going to do if Walmart's your buyer? Yeah, value of my land just doubled, right? So disclose any material benefits as well as any risks associated with the transaction to your buyer. Okay. All right. Any questions about what we talked about today? Any other questions? We have a few minutes left.
Yeah, I got a question.
Okay.
So, and I wrote it down that it seems redundant, and maybe it's not. When I go back to 4.3.1.2,
okay,
and it talks about buyer's agency only. Okay. If I'm checking the front box of being the buyer's agent, doesn't that seem like a redundant box?
Well, the reason that exists within here is because we've added, you know, we've changed these 2 provisions. And so by default, our provision says, yes, we will be a buyer's agent for you if that box is checked at the top. However, I just need to provide you with a change of status, and that allows me to flip into transaction brokerage, right? By checking this box, you're overriding the standard provision in the contract that says, hey, you're allowed to switch into transaction brokerage. So you're effectively saying, no, you don't have
what I'm this. That's what it's saying.
What's that?
It's basically saying no matter what, I'm your buyer's agent, and that's it.
Correct. Yeah.
Okay.
And you have
so okay. Right? Even if it just doesn't give you that other option.
Yeah. Even if you have a relationship with the seller, you have no right to provide me with that change of status to flip into transaction brokerage. You're going to be my buyer's agent only, and you can either refer the seller out or you can treat them as a customer or whatever you decide, right?
All right. So, okay.
Cool. Any other questions?
Jesse, it's Kelly Sturman. I do have a quick question.
Okay.
Back to when you were talking, it's actually twofold. Back when you were talking about working with the buyer that is more qualified over the other, when you say that, you're just saying probably more like from a financial standpoint, you know, coming in with probably the stronger offer, opt for them and then refer out the other. Is that correct? I just want clarification on this, not assuming.
Yeah, and I mean, you got to be a little bit careful about how you do that, right? I mean, because inevitably what's going to happen every time, right, is the buyer that you refer out is going to go, well, Kelly discriminated against me based on my belonging in some protected class, right? Sure. And so you need to make sure your decision has nothing to do with any protected class stuff. You know, hey, it's truly financial, right? I have an obligation to this buyer to treat them with the utmost good faith, loyalty, and fidelity, and you to treat you with the utmost good faith, loyalty, and fidelity. And I'm just telling you, I can't do that for you because I have information about somebody else that would, you know, I'd be putting you at a disadvantage, right? If I did that, I wouldn't be doing my duties to you, right? And so I'm going to do my duties to this person. I'm going to refer you to someone who can do it because they don't have the same information. They don't have access to the same info that I have, right? So it needs to be truly based on, you know, their finances probably. And you don't always know all the details but in many cases, you kind of have an idea of like, hey, this person has more money to put down. This person has, you know,
Cash over
appraisal
whatever.
gaps and whatever.
Yeah. Okay. You answered my question there. Other question is, and this is actually even kind of happening to me right now, especially when, for example, myself, an investor, I've got interest in the house and thinking about putting an offer, and then I get the phone call from prospective buyers that you've got to always trump them first, right?
Well, not necessarily. I mean, what you shouldn't do is you shouldn't compete against your buyers, right?
Right.
That doesn't necessarily mean that, you know.
So just so you know, in the past and even right now, like I'm like, I guess it's more for me. Like, okay, I'm going to always put my client first.
Well, again, it doesn't mean that you can't pursue the property, right? It's just you shouldn't be pursuing the same property as them if you're representing them in, you know, obviously you're going to be representing yourself. And so you can refer them out, right? And again, you don't necessarily have to tell them why, but you can refer them out to somebody else and then still pursue that property, right? And go about it that way. It doesn't mean that you have to not put an offer in or anything else, right? I mean, you're just as much a buyer as anybody else. So, but should you pursue a property in which you are also helping a client pursue a property, I think you're
Sure.
crossing lines there.
I would agree. I just didn't know what the protocol was.
Yeah, refer them out, or obviously
One property, right, Jesse? Just that one property.
or just not, yeah, just for that one, but or just don't pursue that property. But again,
That's what I've done in the past.
To your buyer if you're going to refer them out to somebody else.
Okay.
Okay.
Thanks for the clarification.
Yeah, good questions. All right, anything else before we take off? Okay. We'll see you next week on the 4th. We'll pick it up in section 7. And then again, we'll have the class on the 7th. For any Castle Rock agents who were on there, that will just be the same as what you guys already had. And then for you guys in Northern Colorado or anyone who didn't have it in Castle Rock, effectively it's kind of like 3 classes combined into one. I teach a class on additional provisions. Right? I teach classes on attorney's clauses that, you know, from Damien's clause manual. And then I've taught a class on, you know, being competitive in a multiple offer situation. And yes, those are all 2-hour classes. And yes, we're going to squeeze all 6 hours into 2 hours. And so we really strip all the fluff off and just try to cram it all down into 2 hours and just give you the best of all 3. So that's what that class is designed for. So that'll be on the 7th, but that'll be 12 to 2 instead of 9 to 11. So plan on that. And if you guys have any questions in the meantime, give me a shout.
Thanks, Jesse.
Okay, we'll see you guys.
Thank you.